This is the regular meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force. Called to order, actually, it's a special meeting. It was rescheduled. Called to order at 4 o'clock on February 21st, 2012. Could you call the, Ms. Osbury?
Yes.
Could you call the roll, please?
Yes. Chair Allison Washburn.
Here.
Vice Chair Snyder. Vice Chair Nee.
Here.
Chair Wolf. I'm sorry, Member Wolf and Member Johnson.
Here.
We have a quorum.
Thank you. Did you call the next item on the agenda,
Excuse
please?
me, Madam Chair.
Oh.
I'd like to move that we excuse members Snyder and Wolf.
Do you have a second?
Yeah, second.
Is there any public comment on the motion?
Hello. Unfortunately, my name is Jason Grantcars, and I've been here before. Member Wolf is supposedly the Disability Task Force representative about my case regarding my medical records, which were denied. And of course, this wonderful process, which is set to fail, has continued to do so. And my due process is being violated because he's not here to represent or help me in this and answer the questions as to why the representatives aren't here, especially considering the fact that I motioned the chair for video conferencing just so that it could be accommodated since it wasn't last time and it was predicted to fail this time, and thank you for having done so.
Are there any other comments or from members of the public about the motion?
Madam Chair.
Member?
Yeah, I think it would be appropriate to respond to Mr. Garza's remarks. Mr. Member Wolf has had a health emergency. He is going to be out for approximately 4 weeks. We regret as much as you do that he is not going to be with us today, but this is something that cannot be helped. So, he is not here in a willful absence, nor is Member Snyder. Member Snyder has work and family obligations. No.
No, not at this time.
Thank you.
I believe the motion is appropriate.
Is this about the motion on the floor?
No, I'm confused about this agenda. I got an email saying I was supposed to be here. My item is at first. I don't even see it on your agenda today. So I'm very conflicted.
Let's take care of this motion, and then I'll hear questions about the agenda. Ms. Osbury, would you call the roll, please?
You want call item number 1 you're saying? Or?
On the motion on the floor to excuse members Wolf and member Snyder.
Okay. So I'm confused.
Right. It's for us to vote on the motion.
Oh, okay. So the motion on the floor is to excuse Member Snyder and Member Wolf?
Yes. Mm-hmm.
Okay. So it's been accepted. Motion's been accepted.
Oh,
No, you call the roll. Ask for each of us. Call the roll. Ask each of us to vote, and then you announce what the vote was.
Okay, I'm sorry. So the motion on the floor is to vote to excuse Member Snyder and also Member Wolf. Chair Washburn.
if you would call me last, that's our
Okay.
convention, right? Okay.
Member Nee.
Aye.
Member Johnson.
Aye.
Member Washburn.
Aye.
Motion passes.
Okay, could you call the next item on the agenda,
No,
please?
let's ask that woman. Let's ask
Well,
that
okay, actually, the agenda changes. Would you approach the podium?
Thanks for hearing me. I'm Susanna Robbins. I'm the director of the Film Commission, and I had received an email that I was supposed to attend today regarding Nick Pasquarelli's complaint against me which has been ongoing since September. This is like the fourth time I've appeared, and nothing ever seems to be accomplished. But I've given him all of the materials he asked for, and so I showed up today to confirm he has been given everything he's asked for, and I expected him to be here as well because I had been given an email saying that we were first on the agenda for today. So,
Member Johnson, would you refresh my memory about, I know that this was either withdrawn or continued, this matter. Do you recall?
I think Mr. Pasquarello asked if he could continue because he couldn't be here. But I'm not the chair, so I don't know exactly what happened. I remember that email or why it's off the agenda. But if it was continued, you should have received some kind of notice.
it was continued a time ago, and then I fulfilled...
It was continued this time. I mean, he was requested to be continued. The complainant requested that it be continued. But I don't know.
So if I'm not notified about that from the committee, it just continues to go, because every time I do this, I mean, I'm the director of a department that only has 3 people. We handle all the filming permits in San Francisco. My plate is this full, and I have spent literally probably 5 days and hours just on this one thing, where I fulfilled his request months ago, and yet I keep having to come back here, and I find it a real waste of city time that I'm being paid to do a job that I can't do when I'm here doing this, and it just feels like a misuse of time. And I have supplied him all the documentation he asked for. So I sent a copy to the Sunshine Committee. So I'm kind of at the end of my rope with frustration, because I just feel like this is never ending, and yet I've completed my obligation.
Okay. Well, Mr. Pasquarello asked that this matter be continued, and I'm now recalling that he had received some information from you. The last time we heard this, I believe he just received a lot of information and hadn't had time to go through it. So I think that's why the matter, to make sure it was all there. So I think that's why the matter was continued. And when he asked to have it continued from today, I dropped it from the agenda. And you should have been notified that that was the case, so you wouldn't have had to appear today.
Okay.
And I regret that that happened. The next time it's on the agenda, if it's on the agenda again, you will be notified. And I apologize for the oversight.
So
Is there some way that we can have I know we can't discuss the item because it's not on the agenda, but I know that the issue was about redacting information. Is there some way that we can get the information from her so that we can have her not appear? Is there some way that we can?
I mean, I gave him the information again with no redactions. So, and I believe that I sent a copy of that to your office. So if you want, I can send it again. But everything is there.
Member Nee?
Well, my suggestion would be to contact Mr. Pasquarello and ask him if he has received all of the information that he requested, and that the order of determination has been complied with. And if not, we can reschedule the matter. And if he has received it, if he's satisfied, we don't need to do anything more with this.
Right.
Then, so does he need to submit something to you all to say, I dropped this, or how do we finalize it?
I believe at this point, we need to contact him and get his
determination as to whether or not I supplied anything.
on it and go from there.
Okay.
And then we will let you know.
Okay.
Could you, we've had a change of administrators. The administrator that was here before is not here. So if it's possible, if you would forward the documents again, just because we have a new administrator and we're not sure whether we have it or not, then we would see because the order of determination was specifically the same documents with the information redacted, and we could clearly see that on our own too.
Okay.
So that
I'll send you
it'll be
a-
one of those things where maybe the administrator can remedy what's occurred here outside of a hearing.
Okay. I'll do that.
And, we apologize for you're not getting the notification.
Okay. Well, thank you. And if it does come up again, and I have to come back here, is there a way to have it on the beginning of agenda, since it's been so many times that I've been here? Because I know today I was supposed to be, if we were going to be here, I was told we were the first on the agenda.
Well, I would think that since this matter is being continued and has been on our books, so to speak, for a good long time, I would tend to put it close to the beginning.
Okay. Thank you very much. Thank you for your time. I appreciate it.
Thank you.
Thank you. Okay, now, Ms. Osbury, would you call the next item on the agenda?
Item number 2, adoption of January 10th, 2012 regular meeting minutes.
Move to approve.
Second?
I had a couple of typos towards the end of the minutes. Overall, I think they look pretty good. I can read them now, or I can give them to you.
Yep. You
I-
give them
Okay,
to
well, I'll just read them for the record and then give you my hard copy. Page 4 of the minutes, item number 7, the last 2 lines. Her should be he, striking the R, and then there's an extra period after 5 years. Then item number 9, the second sentence, Chair Washburn said with a small s that the amendments would be on the next month's agenda is how it should read. So I'll give this to you. Member Nee?
Yeah, Madam Chair, I have a number of other fixes, and I will note that these are all form and not substance. I mean, substantially, the minutes are, as I see it, accurate and thorough. In item number 3, paragraph 5, line 3, there should be a period after the word Mr. In item number 4, the public comment paragraph, lines 1 and 2, this is a grammatic thing. The reason was that, not the reason is because. Also, on line 3, after Ethics Commission, there is an antecedent with the pronoun they, and it should be it. Ethics Commission is singular, and so any subsequent referral to it should be singular, so it should be it rather than they. At the top of page 3 of the minutes, which I believe it's the same item, item 4, top of the next page, and I think it might be packet page 9, the word of should be inserted between names and who. In item 5, in the motion paragraph, it refers to HIPAA, and that is the first reference. And since these minutes are for the public to understand what went on here, we should actually, in a first reference, we should spell out what HIPAA is. So that would be Health Insurance Portability and Accountability Act, I believe. Also in item 5, in the public comment paragraph, the word provide should have an S. It should be provides. In item 6, paragraph 1, line 2, follow-up should be hyphenated. In item 7, line 1, I believe the correct name of the person is Rita O. Flynn, O''Flynn. And last but not least, in item 10, where it says the adjournment time, I believe it should be a colon, not a period, where the hour and minute is are mentioned. I think what 6:51 p.m. or something like that. It should be 6 colon, not 6:51.
Thank you.
Did you get all that? I was going kind of a mile a minute.
So that's why we record it, so I can listen
Okay.
back.
Move to accept the amendments?
There has been a motion, yes.
Oh, okay.
Is there
And
pub-
a second.
Yeah, you did. Is there public comment on the motion to accept the minutes?
David Pilpel, good afternoon. The one binder is out here. The second binder with the packet for the meeting is not. Do we still have that second binder with the packet material for the meeting? Okay. It will just leave that out for today, and in the future we'll have that. Otherwise, thank you. And if there is some confusion about the corrections to the minutes, maybe Member Nee could provide a written copy. So, thank you.
I have a question on number 3 on page 2. There's a line, Mr. Song answered questions from members and was seen leaving the hearing room. That's probably correct, but the time is not noted, so it's hard to tell exactly when that was in all of this discussion. So maybe if Mr. Song repeats his walkout at the next hearing, the clerk will note the time. Thank you.
Thank you. Are there any additional public comments on the motion to approve the minutes? Seeing none, Ms. Osbury, would you call the roll, please, for the vote?
Member Nee,
Aye.
Member Johnson,
Aye.
Chair Washburn.
Aye.
The motion passes.
Would you call the next item on the agenda, please?
Item number 3, discussion on changing the time the Compliance and Amendments Committee meets from 4 p.m. to 5:30 p.m.
All right, the reason we're entertaining this possible change is so that we'll have access to, I guess it's room 406. There's a meeting there before us, and it tends to run over. Member Nee?
Madam Chair, if memory serves me correctly, we were also considering changing the day of our meeting, because right now, particularly...
It already is changed.
Oh, it already is. So
We already voted on it at the full task force.
Okay, so my recollection then needs shoring up. And please refresh my memory. What day are we going to be meeting?
The third Tuesday, like today.
Okay, so the full task force is meeting on the first Wednesday,
Okay.
and
right.
this will be the third Tuesday. Okay,
Same as today.
okay.
Madam
Member
Chair?
Johnson? Oh,
I'm sorry. Go ahead, please.
I was, at the time, the previous administrator may have booked 406, but we have to double check on it. So there's Andrea, Ms. Osbury will check. Whether this room is available or 406 is available, so we might have to revisit this item depending on the verification. The 406, it turns out, is booked through a different group than the other rooms, and this was just something we realized recently. So we have to double check if 406. Now, I don't know what the members think about changing the time.
Madam Chair?
Member Nee?
I would have no problem with it, but particularly since members Snyder and Wolf are not here, for us to make that decision without them, I don't know if I'd like to do that, although both of them work.
Mm-hmm.
I imagine, I'm guessing that for Member Wolf it would be easier for him to attend. For Member Snyder, there might be a problem because besides his job, he also has a family, and if we start at 5:30, he might not be able to stay through an entire agenda. The other thing I would say in favor of it is that since we are going to continue meeting on Tuesdays, putting the start back to 5:30 would mean less of a conflict with the Board of Supervisors. And I know that's one of the things that citizens have, one of the issues that citizens have brought to us is our meetings conflict with Board of Supervisors meetings. And if we meet at 5:30 instead of 4, in many cases, that conflict would be removed.
Okay. Well, let's hear what the members of the public have to say about this. Our discussion for changing meeting times.
David Pilpel again. I think this committee at one point met at 3 on occasion and mostly at 4. If it's a combination of members of the public but also city departments that are responding and follow up to complaints, I think having more of the time during the workday, or at least having the opportunity for it to be at the end of the day so people can plan accordingly. On balance, I think 4 o'clock still kind of makes sense so that folks that need to be heard before 5 because they have evening obligations perhaps can be accommodated, and those that can't be here before 5 can be also accommodated. The task force has long had a policy that general public comment at both the full task force and at committees is heard as the first item after 5 o'clock so as to accommodate members of the public in that way. So if you can make a standing reservation for 4 o'clock, whether it's in this room or 406, and adhere to that, and if somebody at assessment appeals or elsewhere needs to be reminded of their room reservation, then so be it. I mean, in fact, 406 is controlled by the Assessment Appeals Board, which is ultimately part of the Board of Supervisors, and there is that. So I guess I would tend to favor keeping it at 4 o'clock. Thanks.
Thank you.
I have a comment that I'd like to interject on the record, for the record, concerning this. Some of the things I've heard in the last few moments, especially from the prior person that was here about the agenda and the prior administrator, some of the things I heard from Mr. Nee right now about the prior administrator maybe having contacted and said, you know, is this going to be okay for scheduling of this room? I still am not confused as to what happened to the prior administrator, and maybe some of the methodology that he used and some of the failings of the prior administrator in addressing some of the correct procedure that maybe Mr. Nee is trying to cover up for and, you know, double check on. And naturally, you know, the failed procedure of having that woman here again when, you know, it was supposed to be off the agenda. So, you know, I'm just wondering what's going on, because I know from personal experience, for the record and on the record, that I've had prior IDRs which were not handled correctly by the administrator. And not only that, but when I contacted the chair and everybody in this rig process, it was never explained. There was no response. There was no there was no area to fix the error, no room for correction, because naturally the failed rig process just continued. And
Sir,
as such,
Mr. Garza, would you direct your remarks to the item on the agenda?
that's what I am. Regarding the item on the agenda was the hesitancy of the prior administrator and what happened and why, you know, the comments that I heard.
No, okay.
Thank you.
Is there additional public comment on changing the time of this meeting? Okay, seeing none, the matter's back with the committee. Member Johnson?
I will say that one concern I would have about changing it, I appreciate Mr. Pilpel's comments about having the time divided a little bit, but we did talk to the clerk's office, and we would like to continue to have the Compliance and Amendments Committee staffed with the clerk. And there's a possibility that the other committees may be having to take rotating minutes. And I think that it may be easier to have the Compliance and Amendments Committee staffed if it begins at 4. So that's something we could take into consideration. Now, that the only reason the timing is that the people who book the room sometimes have closed sessions. And when we had the meeting on the second Tuesdays, we apparently didn't run into that problem, but on the third Tuesdays, we might. So if we booked it at 4 and they had a closed session, that would take priority over the start of our meeting.
I'm wondering if this is something that warrants some continued thought and discussion.
And now we have to check on the status of the room, too.
Right.
Madam
Member
Chair.
Nee?
Well, one other thing we might consider is not necessarily pushing it all the way back to 5:30. Maybe a 4:30 or 5 p.m. start would be feasible and more accommodative for others. Something we might consider.
A compromise to
Yeah,
perhaps
depending-
5 o'clock?
Perhaps, depending on, again, room availability is one of the issues we're dealing with here. So, that would be something we'd have to ascertain, but it's certainly, I think, worth considering.
So I would move to continue it to the next meeting and ask Ms. Osbury to check on the room availability.
Right. Room 406.
Second.
All right. Is there any public comment on the motion to continue this item to the next meeting?
David Pilpel again. I think that's fine. Some further research would be in order, both on the staffing times. That makes sense. I think that there's also a little shuffling going on in City Hall since redevelopment no longer exists. They were on certain Tuesdays in 416, so that frees up a slot there. So if someone was in here at that time, they could move to 416. I don't know that this committee needs to meet in 416, but that kind of gives a little more space. There are times when there are 4 or more meetings going on in this building in the evening, and I don't know that third Tuesdays are one of those times, but there's just a lot that goes into scheduling considerations. So continuing it will give you some more time to sort those out. Thanks.
Thank you. Is there additional public comment on the motion? Seeing none. Ms. Osbury, would you call the roll, please, on the motion?
The motion on the floor is to continue the item. Is it also, just for clarification, to check into a room availability for 406?
Or 408,
Or
depending
408.
on what the schedule is for the third Tuesdays.
Okay. Member Nee,
Aye.
Member Johnson,
Aye.
Chair Washburn.
Aye.
The motion passes.
Ms. Osbury, would you call the next item on the agenda, please?
Item number 4, file number 11081, continued hearing on the status of the November 29, 2011 order of determination of Jason Grant Garza versus Department of Public Health.
Okay. I'd like to remind everyone that the purpose for this hearing was to discuss a particular part of this matter, and specifically to hear a presentation from a HIPAA expert, because the full task force thought that we needed some information about this matter. It's after much discussion, we found that we didn't really understand all of the issues clearly, namely whether city medical facilities, clinics, and so forth can require a person to sign a HIPAA release for his or her own medical records. We saw both sides of the issue, and we needed to hear from an expert. Member Wolf, as we've explained, has been ill the past week or so, so we don't have a presentation. And the item is on the agenda, and I'd like to entertain a motion to continue it because we cannot proceed as planned. So
I move to continue it to the call of the chair for when the HIPAA, rather than bumping along, hoping that a HIPAA expert is scheduled, unless another member of the Compliance and Amendments Committee is going to take it up. It's Member Wolf that has really put forward that every time that he really encourages this to happen. And unless one of us is going to schedule a HIPAA expert for the next meeting, we need to schedule them so that it's actually happening and not put it on the agenda and have everybody show up here and have it not happen again and again.
Second.
So the motion is to continue this item until there is a HIPAA expert scheduled, so not to continue to put the item on the agenda and not have the HIPAA expert that we need in order to proceed. Is there public comment on this motion?
Yes. Unfortunately, my name is Jason Grant Garza, and my public comment concerns the fact that it's very misleading. First of all, during the last hearing that we had here, Mr. Nee spoke to the fact that the order of determination was wrong, so for it to be said that this is only about the HIPAA stuff is not correct. The procedure, which I followed up on about the order of determination being wrong, was never followed up conveniently, naturally, and quite expectedly by you, like by the Ministry of Sunshine. Unfortunately, also, we are negating my due process rights. This thing has been dragging on for an IDR, and the fact that you cannot have HIPAA people available or the availability to video conference them has pretty ineffectively tied my hands for an IDR, which should have been filled within 24 hours. Also, this is a public document that we have precedents from the prior Sunshine Task Force having ruled that medical records were, available to me without having to sign. Just all these facts and all this whitewash that's continuing to evade my due process. I'm once again not given an ETA as to when I can expect the HIPAA stuff. I'm not once again given a response as to the incorrect order. I'm not once again, given any response as to the procedure and how it is rigged to fail and how it's doing repeatedly. How many months does it take to get a HIPAA expert? I think any reasonable man would be asking that question of this committee in full sunshine, which is supposed to expose the truth, to disinfect that which is foul, malignant, and not working. Now, the simple fact that I, the complainant, is still here while the other side is not here is once again evading my due process rights, because another thing that was incorrect in the order of determination was the fact that there was never a knowledgeable representative sent. That is also on the tape during the hearing. There are many issues that are getting glossed over by bad paperwork, bad procedure, and not the whole truth. So for the record and on the record, I'd like for it to be known that you're continuing to harm me by this farce of a process that is not accountable, that does not respond, and as soon as I sit down, I'm sure that you will take your vote and move on to the next thing, which is not reality. Thank you.
Thank you. Is there additional public comment on this matter? On the motion, rather? Seeing none, Ms. Osprey, would you call the roll, please?
The motion as stated by Chair Washburn. Member Nee?
Aye.
Member Johnson?
Aye.
Chair Washburn?
Aye.
The motion passes.
Thank you. Would you call the next item on the agenda, please?
Item number 5, next steps on Ethics Commission proposed policy for handling sunshine-related complaints.
Okay, I just wanted to bring everybody up to date. Right now, it looks like only one of the only date that we're entertaining with regard to this joint meeting is, I believe it's March 26th, or is it March 23rd?
23rd.
23rd,
March
I believe.
23rd. So it's been difficult getting all of these busy people to meet. And we have not yet responded back to the Ethics Commission about the 23rd, but that's what we're looking at. So we have some more time than we thought we had. Members? We have a memo from Mr. Grossman that goes through the Ethics Commission's revised regulations. He's drafted a response for us and has since sent a briefer version. We would also want to have a cover letter, and these materials would go to the Ethics Commission before a good week or so before the joint meeting. Mr. Grossman has suggested that we have another attorney look at these materials. So that's one thing we need to talk about. So those are the various issues that we need to discuss right now. So, members?
Well,
Member Johnson?
Member Snyder has indicated he's the attorney member, that he's unable to participate. And the other thing on the table is that DCA 3 has indicated that our budget hours for the fiscal year are up. And so if he were to review it, we would have to request specifically from his supervisor whether he could spend that time. So we need to decide if we think that that's a useful use of our time. And then there was some discussion of whether Member Nee might know an attorney that might be interested in looking at them.
Well, there are a number of attorneys out there who specialize in sunshine law, and I'd be happy to try to contact them, see if any of them would like to weigh in on this. I'm wondering, though, you know, I'm coming right off the top of my head right now, and that is, with all of the back and forth that we have with the Ethics Commission, I'm not sure there's an outside attorney who would really want to get involved in that particular kind of dispute that we have with ethics. There is the whole question of how much authority we should have within the task force, but right now that's pretty plain under the Sunshine Ordinance that we really have very little. If the committee wishes, you know, I'll be happy to approach some of the attorneys I know who specialize in sunshine law and see what they have to say. I'm thinking people like Terry Frank of Californians Aware, Peter Scheer of the California First Amendment of the First Amendment Coalition. I could start with them, see where it takes us.
Okay.
There's also Thomas Burke, who did a great deal of work in drafting the language of the current ordinance, which appeared on the ballot in 1999 as Prop G. Perhaps he would be willing to give us some input. So I can start with those three and see what, if any, guidance I can get from them.
So it's Thomas Burke, Terry Frank, and
Peter Scheer.
Peter Scheer.
Yeah, Frank is Francke. Thomas Burke is Burke. Peter Scheer is Scheer.
Okay. I think we should hear from Mr. Grossman, if you'd like to even come up here and sit with us, or at your pleasure.
Well, I know Tom. I know him I've dealt with Tom Burke. And Davis Wright, I know them well.
Mm-hmm.
I was, in fact, when I was practicing, I shared their office, so I know them
Okay.
pretty well. In terms of who to pick, I actually had in mind someone other than the regular people. I was thinking of someone within the lawyers who are active in the Society of Professional Journalists. Mark,
Conrad.
pardon?
Mark Conrad.
Yeah, maybe Mark or somebody like that. That would be my preference. I can talk to Tom. I'll call him. But I don't know if we can ask somebody to get deeply involved. Because they have to go back, review everything that preceded this. I think I'll just start with Tom, if that's okay with you, and if that doesn't work, then I'll let you know. How's that?
Member Nee?
Yeah, also, I think, what do we really want to ask these outside attorneys? What should we ask them to weigh in on?
You know, I've spent so much time on this that I've convinced myself of everything I've written, that there's, it's perfect. But I know that isn't always the case. So what I was looking for is somebody who was going to look at it critically without reinventing the wheel. We just wanted to make sure all the pieces came together in the way in which I think they should. And I wouldn't ask anybody to spend a lot of time on it. I think a trained lawyer can look at something in an hour or two and take it apart if it's not well considered. So that's really what I had in mind. I mean, I'm very comfortable with it, but I think for the sake of making sure that we don't have red faces at that meeting or before it, it would be better if someone had a second look at it.
Okay.
And I will ask Tom to do that.
So this is really to get a pair of fresh eyes.
Yeah.
And I just wanted to say that I read your edited version, the 6-page version, and found, this psychology professor could understand it more or less.
Well, you can grade it, and then we'll see what happens.
But, okay, so you'll take the lead on getting...
I'll take the lead on it, and if Tom or someone in his office would not do it or could not do it, then I'll let you know.
Okay.
Okay.
Thank you. Thank you.
Can I ask you a question? Before, when we were talking about this, before the ethics commissioners decided to change their regulations after the Jewel Gomez Sue Cawthon case, our response was sort of focused on the reason why we didn't think that they should, that they should have the two separate tracks, the referrals versus the willful violations. But now it seems like, I want to make sure I'm understanding it. Now it seems like we're going to have the idea that they're not limited to only department heads and, that managerial employees also fall underneath their jurisdiction, right?
What they want to do is limit it to two categories of elected officials and department heads, and then only for willful violations. And by doing that, they essentially exclude 98% of the population that would appear here, but not there. And the burden, of course, in proving willfulness is also an issue. You don't really look at that when you just look at whether the record should have been disclosed or not, on the assumption that it should or shouldn't be, not whether somebody had some other motive in not doing it. And that's what they've introduced in these proposed regulations.
So that makes it that adds an additional.
Yeah, well, if you spend the time looking at it and all of the little bits and pieces that they've included, it's pretty clear to me nobody's ever going to be held responsible for a willful violation. If they consult the city attorney, it's not willful. We know what that means. I don't have to tell you.
And then I also wanted to ask one more question about the Appendix C. The Appendix C is not, we haven't really used that. I sometimes put it in the orders of the referrals, referring the orders over to ethics, but we haven't really included it as part of our argument about their duties or requirements.
The appendix, what is it, C point,
It's
C9
like-
point, whatever, or C3.199, I forget what it is.
699.
869. That doesn't apply to sunshine cases, period, full stop.
It doesn't apply to the
It does not
public
apply.
official.
Does not apply. Doesn't apply to sunshine cases. It applies to conflict of interest, ethics, the 5 categories that Ethics Commission is specifically charged with responsibility. It's responsibility to hear or to provide for the ordinance that deals with public access is in a separate statement in the charter. It says they have to make rules and regulations to implement the purposes of that ordinance. So they have a pretty clean slate on how they do it. But they can't do it in a way which actually is restrictive, because the constitutional provision now says anything you do in this area, if there's a legislative or statutory rule, it has to be read broadly. So the tack that they took originally will be all-inclusive. Now they've cut it back to the point where it's essentially non-inclusive. So that's one problem that they have. And the memorandum that I prepared focuses on those few items. And obviously, they, with these proposed regulations, by eliminating referrals from the task force, they have gutted one of the main features of the ordinance, which is the creation of the body that's going to make these determinations, issue the orders, and provide the public with a administrative forum where they can get these matters dealt with instead of having to sue in a superior court. So this is big stuff. And I think what happened was when, this is a personal opinion, if you go through the dismissal letters over the time since the maybe 2005, you can see the progression of how they are dealing with the fact that it's become more and more difficult to dismiss these cases. Originally, you got a 2-line letter or 3-line letter said, not enough evidence, no probable cause, end of story. Then you would get stuff like the city attorney doesn't agree with the task force, and because the city attorney was elected and the task force is appointed, we follow the advice of the city attorney. Case dismissed. But then after the lawsuit, they began to realize that everybody's going to be able to see what's in these files. So then they began to do put a lot more facts into the dismissal letters and found other reasons to dismissal. But when they saw the fact that the task force strongly proposed that it was only essentially a hearing before ethics on referred matters, on referred violations, that was the penalty phase, that triggered what you got, starting with the Ellen Tang case, which is the first one, where Mr. St. Croix said, well, we only hear willful violations, and this wasn't willful. And the person involved was not an elected official or department head. So every letter after that, every dismissal letter after that, there were 9 of them that I saw, had some part of that in it. So what St. Croix is now trying to do is to formalize that view of what the ethics jurisdiction should be. But we know what happened in June of 2010. We know that they had a meeting, the Ethics Commission met, and there was a very long, extended discussion about its jurisdiction. And they finally decided that they would hear these referrals, these plain violations. And so over the next period of time, there was no effort to take that jurisdiction away through the process that they have. But beginning with the fact that it was pretty clear that they were going to have to hear them, and that it was either going to be a penalty phase or a shifting of the burden of proof or some element that would change the dynamics and put the pressure on the respondent, that's when St. Croix turned the switch and said, no, we're only going to do willful misconduct cases. And you could see it, you can just follow it right through. And so the problem is to convince the commissioners, because they have 5 commissioners. Of the 5 that heard the case in June of 2010, there are only 2 left. And so I'm not sure that we're going to have a situation where they're going to be very open to the argument that we're trying to make. I mean, there's so much bad stuff in the regulations, even if they accepted their own proposal on the jurisdiction.
Could I ask you another question?
It's extremely bothersome.
Since you've looked very closely at the letters, I know that they've moved towards saying it's the district attorney and the AG that handles
Yeah.
the enforcement. Do you know how long ago they started doing that?
Pardon?
Do you know how long ago that became one of their responses? Have they always asserted that the DA and the AG are the only people?
There have been a number of referrals to the DA and to the Attorney General.
That they referred?
Well, the district attorney doesn't have any role in getting public records or fixing, improperly held public meetings. That isn't what they do. They handle criminal cases.
Today, a member of the public brought to my attention, I've not checked this out, but they brought to my attention that the Ethics Commission has been sending our referrals on to the DA themselves. Were you aware of that? I was not.
Well, yes, they do. What they do is if there's this 40-day clock that starts running, and they, as a matter of course, would send the referral over and ask them if they want to handle it. And
So
they
that the
always
clock
say
would
no.
turn.
They always say no. And the Attorney General is on record as saying they don't handle local matters, which this would be, but moreover, they don't have any authority under the Public Records Act, the Brown Act, and clearly under the Sunshine Ordinance to deal with this stuff. So the alternative is ethics or the Superior Court, because there's no other city body or agency that enforces your orders. So this is I think it's almost scandalous, to be honest with you, because if they get their jurisdiction limited in this way, you realize that there's no member of a commission, no secretary to a commission. There is no deputy director. There is no deputy whatever. There's no manager that the Ethics Commission could force to disclose a record, because their jurisdiction is limited to elected officials and department heads. So you've got people like the zoning administrator, the city administrator. You just go through the list. I did it. There are 81 boards and commissions in this city. Multiply that by 5 and add another one, maybe every 1 or 2 has their own administrator or secretary. They're not covered. The Library Commission, not covered. Sue Blackman, not covered. And in DBI, they've got 15 deputies, I think, not covered. I've got it. It's in this short piece that I did. So, but I'll talk to Tom Burke or somebody over there and see what I can do.
Okay.
And then we can talk about it again.
Okay, thank you very
Unless
much.
you have some other questions.
Do you think we might have to have a special meeting to talk about it one time before, our next meeting here wouldn't be till the 20th? And if we had it on the joint meeting on the 23rd?
Tell you about special meeting of the task force?
Of the Compliance and Amendments Committee?
Yeah.
We might have to consider that if we want to get because we need to send to the Ethics Commission our response 10 to 7 days before the meeting.
Well, my view was to get it to them a week or 10 days in advance of the meeting.
So that we might need to consider a special meeting, depending
right.
on how it goes in the next week or so.
Well,
We could also, well then, because we We have a meeting of the task force on the 28th, and we have a meeting on the 7th. And then this doesn't meet again until the 20th.
So maybe the 12th, we could meet.
We'll have to see.
I wanted to say that the League of Women Voters has decided to make this issue a priority for action. And I just put a bug in their ear, but they've been following all of this, and they want to be educated about what we're doing here, and they want to be president of the joint meeting. They want to be advocates for us. So having a special meeting where they're invited would be helpful to them. So I just wanted to let you know that this is taking precedence over every other sort of issue that they're interested in, and I wasn't beating them over the head with it.
Do you want to, when David Campos was chairing the Oversight Committee, he wanted to set up a hearing on this. Is that still a possibility?
He's not chair of that committee anymore, is he?
He's not. I talked to him about a week ago, and since we were at that time trying to get the Ethics Commission to agree to a meeting, and they had agreed, he wasn't sure that it was a good time to set up a meeting in front of the board if we could work it out between each other. But that doesn't mean that I couldn't follow up on that. Considering some of the things that that you're saying today about the number of employees and public officials who are not elected or department heads that wouldn't be covered, it's pretty serious, and maybe something that the Board of Supervisors should be involved in. So what do you think? You think it's a good idea to follow up?
Well, my view is that they're going to get a chance at it. If ethics adopts these regulations, there's a 60-day period after they adopt them before they become effective. So there's a chance that you could get something heard in that 60-day period that would change the ethics view of what they should, type of regulations they should have. But I wouldn't necessarily count on it.
Okay. Well, it sounds like we have a plan.
Pardon?
I said it sounds like we have a plan. Member Nee?
Yeah, if we're going to have a special meeting, and I think it's a really good idea that we do so, backdating from the tentative time of our meeting with ethics, which is March 23rd, I would suggest a special meeting on Tuesday, March 6th.
March 6th.
I realize that's the day before the task force, but it would be, I would suggest that it would be a one-item agenda, which would be this item.
Mm-hmm.
I think we could probably get it done in a couple hours, and it would give us plenty of lead time on sending whatever communication we need to the Ethics Commission by, I guess it would be the 16th, March 16th.
I'm
I guess
fine with that.
we could do that, but it might be better if we could move it to the beginning of the following week, because we have the 28th. And then the 7th.
Yeah, well, but would that give us enough time to, reach whatever conclusion we're going to reach, and then communicate that to ethics within the allotted time window? That's my concern.
Well, It's a tough call because I will pretty much not be able to focus intently on the Ethics Commission regulations at that time. Now, I know I'm not the main focus, but it's only us three, which is another thing we have to consider. Depending on if they would be, if they feel that the regulations would have been, we would have had time to have them potentially reviewed by someone that you feel comfortable with by then? I mean, the response to the regulations?
I think somebody who's reasonably familiar with the law, it won't take them long. I don't.
Sure.
That's not the first.
That's what I was going to ask. David Pilpel, I'm sorry, I don't mean to interject, except that I've got to go talk about redistricting in another room here. And I certainly appreciate the extended discussion with Mr. Grossman, who is certainly familiar with this. And I think I may actually agree with Mr. Grossman on part of this. I see in the packet there's a December 8th memo. Is that not the communication that you're talking about from Mr. Grossman? Was there something subsequent?
I'm referring to an edited version of that that's edited down to 6 pages that he.
Okay, because this is a 4-page thing, so.
No, there are actually a number of memos around.
Okay. All right. Well, maybe if that latest thing can be made available, I'd be interested in reviewing it. In summary, and then I've got to go and we can have more discussion about this at a subsequent meeting, I do think it's worth having some meaningful discussion, whether it's on the 6th or some other time, the 12th, for example, prior to the meeting, the joint meeting on the 23rd, and prior to your next meeting on the 20th, assuming that that's all still on track. I think that there are some other options besides the outside counsel that you've talked about. The city has relationships with other municipal law offices that have been used in the past, including last year when there were conflicts because the city attorney was running for mayor, et cetera, et cetera. So the Office of the County Counsel in Santa Clara County, someone from San Mateo, and I forget who, the Oakland City Attorney's Office, and the Oakland Ethics Commission have been used on occasion. They are familiar with ethics and its procedures, yet don't have a particular vested interest in the outcome of this thing. So I would suggest them as some options, and you might communicate in writing or otherwise with the city attorney and say, given the number of hours limit that you've gotten to for this year and the nature of the relationship between this body and the Ethics Commission, perhaps the city attorney could arrange for some limited time from some other office to assist in reviewing the proposed regulations. That's a thought. Also, Daniel Purnell, who used to be the head of the Oakland Ethics Commission, I think retired from that position, and yet is also familiar with San Francisco ethics and its regs and whatnot. He might be someone that similarly could be used in some capacity here. The point that I was going to make very briefly, in agreement with Mr. Grossman, I believe, is that the charter provision about handling of complaints, I think, is fairly specific to the type of complaints that are governed in that charter section about ethics laws, conflict of interest, laws that are clearly within their jurisdiction. I think the handling of referrals under Sunshine is governed by either 67.30 or 67.34 and its related aspects. So I think there is, in some ways, more latitude that the Ethics Commission has for handling these referrals, and that's something that needs to be teased out of the discussion. I could go on at greater length, but again, I've got to go talk about redistricting. I think that there may be a way to get to a better place here. I think it's unfortunate that there's been sort of an unhappy situation between the task force and the Ethics Commission on handling of these referrals. These are important cases, whatever one's perspective on them, and they need to be handled appropriately. And sort of one part of government saying this is important, the other part saying, not so much. We've got to find a way to bridge that gap, and I hope that happens. Unless you have questions until next time.
Don't you think the Ethics Commission does that to other things too?
That's a broader question. I'm not sure I want to address that now. But nice try, Member Johnson.
I just want,
Yes.
I just think that for the record,
Yes.
that when we talk about the task force, I'm not directing it at you personally, but when we talk about the task force and the Ethics Commission,
Yes.
it frequently falls to the idea that the task force has a problem. And technically,
And I'm not saying that.
Technically, I'm just saying that the Ethics Commission, there are a number of entities that have a problem with the way that the Ethics Commission
And
tries to prevent itself from having to make a decision or take a stance on something. So I just for the record want to say that it's been pointed out by the civil grand jury, and it wasn't solely focused on we talk about that here because we're the task force, but
Right.
it's not solely focused on the task force. There's a problem there too. So just for the record.
I think that's a fair criticism. I think there's also some fair criticism leveled at the task force and how it handles complaints. So there's some disagreement and unhappiness in the kingdom overall. I'm not advancing a point of view that one's right and the other's wrong, just that we should find a way to resolve this. It is fair and appropriate for different parts of government to have different views, but we should have a respectful way to resolve that, and that's what I'm hoping happens here. So is that a nice, skillful way of, yes. Until
Or
next
we
time.
had the same wish for an outcome between peers, Ethics Commission
Yeah,
and
I mean, I
Sunshine
think,
Ordinance
I
Task
think
Force.
both bodies have roles to play, and if you can clearly define what those roles are, you do the best job you can within your role, they do the best job they can within theirs, that's to the good. To the extent that there's ambiguity and confusion about who does what, that would be good to work through. All right, I got to go more next time. Thank you.
Thank you. Is there additional public comment about this? I was looking at my calendar and wondering for a date for this special meeting. I think we should pin it down now. Since we're contemplating meeting on a Friday for the joint meeting, I'm wondering, so Fridays seem to be a possible meeting day. I'm wondering about March 9th. It would be after the full task force. I think that would give, that would be 2 weeks before the joint meeting if it happens on the 23rd. March 9th?
That's Friday.
March 9th, I'll be in Chicago.
Oh, okay. When will you be back from Chicago?
The 11th.
The 11th.
March 12th?
The 12th then?
Well, without knowing when the Ethics Commission is going to meet with us, we can't. Well, I guess
Right,
we
we
could
haven't-
anyway. We could. But
We could still meet on
Yeah.
the 12th, and if the March 23rd meeting is moved, we would, have more time.
Can't you do it before I mean, those plans I made a long time ago, so, but if you could do it the Tuesday, the 6th, I would be here.
It's just, Chair Johnson was saying that's before the big task force meeting, and we will have just had another task force meeting, and she wanted more time.
Okay.
Well, some of this will be a little bit about the clerk too.
Pardon?
Some of it will be about the clerk being able to prepare for two meetings in a row on the 6th and the 7th, but that, it's very important. So if we had to try to have this would only have one item on it. So it wouldn't be that big of a paper intensive kind of thing. So
Well,
you could,
I'm at your disposition any day other than the 7th through the 9th. 7, 8, and 9, I can't make it.
We could see if there's rooms available on those days, like the 6th and the 12th. We could also contact the Ethics Commission and see if they have if they can meet on the 23rd.
Right.
And then, because then we could pick, then if, depending on which one had a room available.
Okay, so we have to make sure that the Ethics Commission can meet on the 23rd, and then we have to see about room availability for either the 6th or the 12th. Member Nee?
And if they cannot meet on the 23rd, when?
Right, yeah.
Okay.
Thank you so much. Okay, we're past time for general public comment for items not on the agenda. Ms. Osprey, could you call that item, please? Item number
7.
7.
Item number 7, public comment. No.
I'll give the member of the public a minute.
I want to ask if they have any.
Is there any general public comment for items not on the agenda? Okay, seeing none. Ms. Osprey, would you call the next item on the agenda?
Item number 6, then, we're going back to 6.
6.
Item number 6, continue discussion on the proposed amendments to the Sunshine Ordinance.
Madam Chair?
Member Nee?
Yeah, I think first we should refresh ourselves with the timeline. I think the intention is that we get something on the November 2012 ballot, and so we'll need to back time it to the point of how soon we would need to get whatever it is we're going to get to the to members of the Board of Supervisors. I think our intention, our plan is to find 4 supervisors to sign off on our package. So we would need to find out how much time they would need to massage it and meet the deadline for getting it on the ballot. We would have to.
I'm sorry.
And then we would have to get it to them in plenty of time for them to do that. I have some other thoughts, but I'll leave it there for the moment.
Member Johnson?
I did have the calendar up here before, but it's gone now. I have some concerns about giving a packet of amendments for 4 supervisors to put on the ballot with Scott Wiener's survey going around, because I don't know what changes they would make to it and put it on the ballot.
Well, it depends on which 4 we take it to, but even then, if we find 4 supervisors we feel are reasonably sunshine friendly, there is the possibility that any of those 4 could try to weaken it. There's also the possibility that Supervisor Wiener or another member of the board who really doesn't like sunshine would try somehow to sabotage the effort, either procedurally or substantially. So yeah, if we take it to the Board of Supervisors and try to get 4 to sign off, there are risks involved, no doubt about it.
Could I ask you to describe the process that happened in 1999? The signatures, right? They put it on with signatures.
That's correct. What had happened was we had a package that had been drawn up, and as a matter of fact, Thomas Burke and a gentleman named Stephen LeBlanc, also an attorney, did the lion's share of the draft work on what became Prop G. We took it to just about every supervisor saying, would you be interested in putting this on the ballot for us? We kind of knew that we were really not going to have much success. We were expecting that if we could get 4 supervisors to sign off, we might have to make some compromises. So going in, we figured we had figured out where we would draw lines and where we would let the lines be pushed a little bit. The only 2 supervisors who would listen to us were Tom Amiano and Leland Yee. And that being the case, we got back together within our organization, San Franciscans for Sunshine, and said, okay, if we want to get this on the ballot, it is very plain that we're going to have to do this by the signature route. The good news is we don't have to make any compromises. We can put this on the ballot as we've written it. And so that's what we did. We went out, we had to get, I think, 14,000 plus change valid signatures. So we went out, and in order to do that, we realized we would have to actually get about 18,000, which we did. And so we got the number of valid signatures and got it on the ballot. Doug Comstock by himself collected at least 1,000, I think.
Was there a committee of people that helped direct the gathering of the signatures?
We also, I think we hired Dave Sparrow to hire some people to get some signatures for us. I think he charged us like 25 cents a signature, so that helped. Had we not had his assistance, I'm not sure we could have reached that magic number, but we hired him, and he did. Also, I forget if it was before or after we got it on the ballot, but at some point, Ross Mercarimi joined our campaign and took over the management of the campaign and did an absolutely splendid job. He knew what needed to be done, when it needed to be done, and how to motivate people to do it. And Ross, down through the years, has been a tremendous friend to Sunshine, and we owe him a cartload for it. If we wanted to go the signature route, we would need to find someone to kind of guide things along. I also think that we would need to revisit things, get all of the I's dotted and T's crossed in the text of what we're proposing. Building on what we already have from former member Craven Green and from people like Mr. Grossman, Mr. Crossman, all those people who have contributed ideas. If we're going to do that, though, if we're going to go the signature route, task force can't do it. It's out of our hands. We would need to get people to take it over, basically.
Are you saying because it's a conflict of interest?
Well, the task force, I don't believe the task force has the power to go the signature route by itself. I don't think we could do that. We would have to be, if it's going to be a signature drive, it has to be by a citizens committee. That's my understanding of it. If that's incorrect, certainly I'm interested in hearing that, but my understanding is it would have to be by a citizens committee. And that may be the better way to go.
Yeah, I'm thinking it would be a better way to go. It seems like going the supervisor route is really fraught with a lot of danger. And I'm wondering about holding that could be one of our a regular meeting of this committee and letting the public know somehow, letting the public know that we are considering that we're considering these amendments, and that we believe the signature route is the way to go, and see if there's any interest.
Again,
Is that one way to go?
no, well, we have to be very careful about doing that, about how we go about handling that. What we can say is we believe we have taken this as far as we can procedurally. We don't think that we would have much success if we tried to go through the Board of Supervisors and get this on the ballot that way. So at this point, it's off our agenda. If there is any group of citizens out there that wants to take this to a petition signature gathering drive, try to get it on the ballot that way, more power to them.
So we need to get the deadlines
We
for
need to get-
submission, and we need to finalize the changes.
Well, if we're not going to try to get it on the ballot, we don't need to do anything further in terms of the text.
We would make available what we've done to this body,
We can do that.
whoever comes forward.
We can do that.
Could we hold a press conference and have a press release about this? I'm just trying to...
Saying what?
That over the years, we have been considering ways to strengthen the ordinance. We have some proposed changes. We feel that at this time, it would not work to go through the Board of Supervisors, so there's really nothing much we can do.
Before we do that, could we maybe, at least one of us, sit with Supervisor Campos or Supervisor Avalos and get their feelings on it?
That would be a good idea, yeah. Member Nee,
Well,
would you do something like that?
sure.
Okay.
Let me see what I can do, and I'll let you know.
Okay, great. Any comments from members of the public about this conversation we've been having? Seeing none, the matter is closed. Ms. Osprey, could you read the next item on the agenda?
Are we going to continue it to the next?
Um,
Not the special meeting, but the...
Yeah, let's continue this item to the next
Regular.
regular meeting of this committee, at which time Member Nee will report back about his meetings.
If I could ask, Ms. Osbury, have you seen any of our information on this in your files? We discussed this at some length, but even when I wasn't on here, there was like 3 years or something of discussion about the changes. Have you seen anything?
On the proposed amendments?
Yeah.
I haven't seen anything, but doesn't mean nothing's there. But if you want me to check and see if there's anything prior relating to this, I can check.
Well, I believe the latest version of what we had is on the website.
Okay.
No, we took it down.
Oh, we did?
Because it had never been, we had decided to make the, I forget if we chose 10 things or 13 things to narrow it down, and we pulled the old one down because some of the things there were some things that, like former member Craven Green felt that it was okay to attach the 150-word summaries, and that was one of the things that was up on the website. And then the current version of the task force did not feel that that was working. So when it was one of the things that we didn't choose from it was on the table, but we didn't choose as one of the 12 or 13. So there should be like a bunch of stuff related to huge changes, like every single grammatical error is removed, so it's a massive changes. Then there's a second part that's narrowed down, maybe, I don't know if it's 10 items or 13, something like that. So we might want to look at those again to see, to review them after this time has passed.
I'll look for those items to see, and I can follow up with the members of this committee to see what I found.
And I'll look and see if I have my copies. I have copies of different things in different places.
I know that I have files with specifically about the amendments. The first, when member Craven Green was here, and then I'm trying to remember the dozen or so items that we decided to push forward. Were they were brought to the full task force? Were they approved by the full task force?
I'm sorry, I don't recall.
I don't think we brought them to the full task force. I can't.
I thought we did, but
I can't. You might be right, but I can't recall. I think we might have had a special meeting. Maybe.
Mr. Grossman, do you remember?
It wasn't ready for prime time.
Oh, it wasn't.
And they knew they couldn't get it ready in time for the election that they were shooting for. So they put it on the back burner.
You're talking about the dozen or so items that we...
No, I'm talking about the full amendment. What was done was they being Erica and Rick and...
I was on there too.
You were on
the tail end of that process.
So
yeah.
it was a line-by-line review and change of the entire ordinance. And it took forever. And if there is a version that reflects everything that happened, all of the additions and deletions and corrections and all, I'd be surprised, but it's possible because the former administrator didn't know how to keep track of that stuff. And so I have on my machine what I think is the last version. But anybody, if you want it, you're more than welcome to see it.
Okay. All right, so we will revisit this at our next regular meeting. Could you call the next item on the agenda?
Item number 8, Administrator's Report.
Members, are there any comments on the report?
I have some
Member
questions. Just have some questions. Items 190 through, 11090 through 11094. There are some dates in the status column. I'm just curious to know what they represent, what occurred on those dates. Also, complaint number 11095 and all thereafter, the status column is blank, and I'm curious to know why.
The 11090, that was continued from the 20, it was on agenda for the 24th, but it was continued. The same thing with 11091.
But I think it would be helpful if,
It doesn't look like it's been updated. And then the remainder of them are, some of them are on the February 28th agenda, and some of them are on the March agenda, the March 7th agenda.
also 11093, same thing. But
That's now on the
I
28th.
I think that there should be something more than a date there in the report.
Like if it's a task force continued or.
Something, yeah, continued to or something. And then also, again, going forward from 11095 on, nothing at all in the status column. And, even something like a TBD, meaning to be determined, I think would be somewhat helpful.
I also would like to point out that the complaints now go up to 1210. Just so you guys are aware that they're not, I know they're on the next page, because they were in 2012, but I just want to make sure. There are examples of that in there, of what Member Nee is talking about. If you go back through especially if you go to the like earlier ones, April, you'll see the different notations. Tabled, concluded. It'll say if it went. It'll say what violation was found. Concluded, petitioned, dismissed. So it's kind of how we keep track of it a little bit. And I recognize it may be hard to go back and fix them, but with the newer ones, if we could at least start the process.
Ms. Osbury, is Mr. Rustum still available to kind of help you through in your initial stages?
No, he is not.
Oh,
No.
is he? Okay, well, perhaps then, perhaps Mr. Caldera could help you. What happened to Mr. Rustum? Is he gone from the office entirely, or?
He's no longer with the city.
Oh, okay.
But as far as when I came on board reading this, it is a little, to me, it was confusing, maybe not knowing in depth how the process is and how it works. But in the status area, I'd already started a process for 2012 to make it a little bit more clear as far as what exactly happens to the complaint, the outcome. Because looking at dates is a little confusing. I don't know, for me it is. I don't know about the other members as far as what exactly happened.
Yeah, I personally had no input into this style. So if
Oh,
you
you
have a
didn't? Oh,
style
okay.
that you prefer, as long as we can track it, we're willing to give it a go.
Okay.
Yeah.
All right, good.
So there's no, it was just a way of, going back and seeing, because sometimes we need to see, how many hearings they had to attend and that kind of stuff, so.
Okay.
Thank you. Are there any public comments on the administrator's report? Okay, seeing none. Ms. Osbury, would you call the next item on the agenda, please?
Item number 9, announcements, comments, questions, and future agenda items.
Member Nee?
Yes, I'd like to announce that the Society of Professional Journalists Northern California chapter will hold its annual James Madison Awards dinner honoring champions of sunshine and the First Amendment on the evening of Thursday, March 15th at the City Club of San Francisco, which is at 155 Sansom Street, Sansom at Pine. Tickets are $50 each for SPJ members and $70 for non-members. It's usually a very well-attended and very high-energy affair. Lots of very good energy there, and I hope as many of you as are listening to this can join us.
Thank you. Are there any additional announcements, comments, reflections? Okay, saying none,
Move to adjourn.
Second?
meeting is adjourned. At some 5:38.
5:43.
Oh, 5:40. I was looking at my watch.